Thank you for joining us today, and welcome to the Conn Maciel Carey 2024 Cal OSHA webinar series. We've had a couple webinars already. You've already joined us for workplace violence prevention, SB 553. We've done new updates for Cal OSHA, as well as covering indoor heat. If you have not seen those webinars and you're interested in reviewing them, they are on our website, so feel free to take a look at those as well. And of course, feel free to reach out to anybody on our California team if we cover anything that you have questions about, moving forward. So today's webinar series is Top Cal OSHA Violations. My name is Rachel Conn. I am the chair of the California practice, and I am here joined by my colleague, Samuel Rose, who is in our LA office. I am up in our San Francisco office. So we cover throughout the state, and we're excited to present this webinar for you today. It is a very important topic for many reasons, but we'll go ahead and we'll jump into it and start to cover the major points. If you have questions, feel free to put them in the chat box. We'll do our best to answer them as we go, but if we are unable to answer them, one of us will try to reach out to you after. And of course, as always, you can reach out to one of us directly, and we're happy to answer any follow-up questions that may come out of today's webinar. Again, I'm a partner and chair of the California practice, and for some of you who are still getting to know me, I've moved over from Nixon Peabody last year, and so I'm excited to be here. And not only do I practice in California, but I do national OSH work as well. And of course, my colleague Sam Rose, who is not only supporting in the workplace safety practice group, but also in our labor and employment group as well. So a wide range of expertise and knowledge out here on the West Coast. So our agenda today for the webinar, we're going to start by discussing the importance of knowing the top violations. Why are we having this webinar to begin with? Why is it important that you're here to review it? What we want you to take away from it, or hoping that you'll take away from it, things to think about as we go through the webinar that will help you to hopefully improve your safety programs. We'll also obviously go through the top 10 list, starting at number 10 and ending up with number 1. I'm sure most of you on this webinar can guess what's number 1. If you've done any work in California, it should not be a surprise. And, taking a look at this list, it should not be really, none of them really are huge surprises. And I think, from the get-go, that should be the main lesson here, is that none of these are really surprising. They're the same ones that we see, year to year. And for those reasons, they're really ones that you should be paying attention to and making sure that are incorporated into your safety program and are getting special emphasis in your safety program, because we know year after year, these are the ones that are the main issues. And they're main issues for a reason, because they're easy things to miss. They are maybe very broad, and they apply to almost any industry. And so that's why you see such a high number of citations in these areas. We'll also do a little comparison of how these compare to Fed OSHA. So the lists are very, there are some overlap, but there are significant differences. And so one, for anybody on the call that has facilities or operations outside of California, to take that into account, that, the emphasis areas here in California are different, and the way Cal OSHA views certain areas is different than what you're going to see in other places. So, California is unique. You all know that. That's why you're on this webinar. And that's why we are doing California specific webinars, because of the uniqueness that we have out here. We'll also give you our predictions moving forward. So this list is actually the 2022 list. The 2023 list has not been released yet. Fed OSHA has released theirs. Cal OSHA has not released theirs yet. But again, they're pretty similar year to year. So even though this is not the 2023 list we're looking at today, it certainly covers the things that you need to be concerned about, with maybe one or two exceptions that we'll see some drop-offs, like COVID-19 in 2023 and moving forward. But we'll give you our predictions of what we think we're going to see coming up, and the areas where you should be paying attention to in 2024, because that's where we think Cal OSHA is going to be paying attention to. So again, we'll start with the background and importance of knowing these top violations. So all of this information, it's publicly available on the Department of Industrial Relations website. That is the department where Cal OSHA rolls up into. So we have the link here for you if you want to double check or to check it out yourself. But why does Cal OSHA every year publish the top most frequently cited standards? And that's because, and then again, it's the same reason why we're reviewing them. It's to alert employers about the commonly cited standards, so you can take steps to find and fix these recognized hazards, and to keep Cal OSHA out of your workplace. And hopefully, we're going to go through these today. We're also going to give you some areas where, we see how Cal OSHA cites. So not only that it is a frequently cited standard, but where and how we see Cal OSHA cite, and where we think employers, can put some time and attention to avoid those things. Because a lot of this is low-hanging fruit that can be easily remedied with, some tweaks to policies, procedures, and safety programs. In addition to those top citations, also on the Cal OSHA website, you can find a list of complaints, inspections with initial penalties over $100,000 and above. That's good information, again, to take a look at, to see where the focus areas are. What are the areas that we see employee complaints? That will certainly dictate areas of focus for us. And then inspections with the initial penalties, that gives, those tend to sometimes be frequently, those tend to be, kind of outliers when you see that large of penalties. However, it does kind of give you an idea. How I think that's helpful information is you typically do see a trend of industries where Cal OSHA is focused. So when you take a look at that information, if you want to look at those penalty amounts and where those are, you may see some trends in industries. And then I'm sure most people are aware of the Fed OSHA establishment search. So that includes state plans. So you can go onto that website and put in any company name, and it will provide the if they've had any citations and where. And sometimes that is helpful if you're benchmarking for different industries or others in your industry, things like that. And just a caveat that, that information isn't always accurate. It doesn't always update or update timely. I know it doesn't always reflect everything that happens in the state plans. So, that should really be used as it can be used as a tool, but just know that it's not always accurate. But certainly all of these things are great ways of, as you evaluate your policies and procedures, to give you an idea of some additional emphasis areas. So this is a chart from Cal OSHA's website that gives you how many complaints that they received, the validity of those complaints, and those by validity they mean not based on harassment. So sometimes employee complaints that are made to Cal OSHA are not actually safety related. So when they talk about validity, they're talking about safety related complaints and not necessarily whether or not there was actually a violation. The number of citations issued, penalty amounts, things like that. So what I think is interesting when you look at this information from the past, several years, for the most part, minus, 2020 when we had COVID and we saw an increase in COVID related citations, you'll see it's generally pretty static for the most part. With the exception, if you look at 2019 and earlier, they were issuing many more citations than we are currently seeing. So, some of that may be related to, I don't think it's any secret that Cal OSHA is severely understaffed, particularly right now. The Cal OSHA chief has recently resigned. If you talk to any district manager, they will tell you how understaffed their offices are. And so, I think that part of that is reflected here. And, we'll see how that continues to impact citations and inspections. From my perspective, the past couple of years, we've seen, somewhat of a delay in inspections due to the staffing, understaffing. So for incidents that aren't serious, you may see a delay in having Cal OSHA come out. I know a lot of employers, get excited. That means Cal OSHA is not coming, but unfortunately, that usually means that there's a delay. It also means that it takes a little bit longer to get informals scheduled. So if you are trying to get an informal scheduled before you file an appeal, it can be really difficult to do given the understaffing, particularly in Southern California, San Bernardino. Those areas have a lot of district managers out and district managers in high hazard that are doing double duty. So if Cal OSHA is not getting back to you, that's generally the reason and why we see that. So with that, I'm going to kick it over to my colleague, Sam, to start us off on our top 10 list.
Thanks, Rachel. So we'll go ahead and get started on our top 10 list. And as we review these top 10s, just make a note of how many of these standards are unique to California. As Rachel said in the intro, California is really its own landscape. And so while there will be some similarities, there are going to be a lot of differences. And on that same note, it's important for employers who have operations both in California and across the country to know the differences between the federal regulations and the California regulations, because even if they cover a similar topic, the requirements might be slightly different to very different. And so you want to make sure if you're operating in California that you're operating under the California regulations. It's also important, we keep this pretty general, but you all come from very different industries and come from very different businesses. And so it's important for you to know the most frequently cited violations for your specific industry, because Cal OSHA goes in and depending upon the operation that they're in, they're looking for different violations and different things in that workplace. So this is a broad top 10, but just keep in mind those 3 points as we review these. So number 10 is the emergency eyewash and shower regulation, which is found in 5162. We put the eyewash and the emergency shower requirements up on the slide. The most important thing that we see is accessibility, which requires that it not take more than 10 seconds for an employee to reach the eyewash station. And of course, that's a pretty weird standard, because in order to calculate the 10 seconds between where a person is working and where the eyewash station is, Cal OSHA is making some pretty big assumptions, or can make some pretty big assumptions. But you generally want to make sure that the eyewash station is in close proximity to where employees are working with, for example, hazardous chemicals. We have been seeing a big push by the division to cite employers under the standard, especially more recently. And a lot of these citations will stem from a blocked eyewash station or a faulty eyewash station. Often these stations aren't used routinely, and so it's easy for material or product or stock to build up around these areas. And if Cal OSHA comes in and sees that the eyewash station has, anywhere from packages to a small bucket in front of it, it will rush to cite the employer under this standard. So definitely make sure that these eyewash stations are clear, that they are working, and that there's no obstructions to employees getting to them. We've also seen, and this is kind of a unique aspect, but we've seen a lot of focus, especially here in Southern California and somewhat up in NorCal also, that the division is citing employers for not having an eyewash station when they use a closed loop system for chemicals. We've had some pretty good success pushing back on these citations, but we have noticed an increase in the division focusing on this area. And so if you use closed loop systems, just make sure that you're complying with the SDS, that the closed loop system works, and that it's actually a closed loop system. And you should be in good shape.
And one other thing I would add to what Sam's saying about obstructions is that, Cal OSHA, we've seen Cal OSHA certainly take very broad stances on what's considered an obstruction. I've had employers get cited for having a hose in front of an eyewash, because Cal OSHA's position is that if somebody is rushing to the eyewash station and they have a chemical in their eye, they could trip over that hose. And many of the times, as Sam mentioned, there will be movable things that may be in front of it. So in the instance of the hose, the employer happened to be cleaning an adjacent area, and the hose happened to get in front of this eyewash station at the unfortunate time that Cal OSHA also was inspecting, and got a citation. I've also seen, again, as Sam was talking about, movable buckets, that were left in front of an eyewash station, and Cal OSHA's position, again, it doesn't matter if it's movable or not. If the employee may, in a rush to use it, it in some way impedes their ability to get there in any way, that's a violation. So it's certainly one area, when you're doing your inspection checklist, when you're training employees, we have to really, really be sure that we're keeping those areas clear, even if it's temporarily, and even if it's something that is movable. Just be aware that, if they come in and they see it, it's going to be a citation.
Thanks, Rachel. So number 9 is portable ladders. These are found in 3276. And this regulation covers a wide variety of topics related to ladders, but design, construction, selection, maintenance, those kind of things. And of course, accidents from portable ladders can be somewhat common. So you want to make sure that you're complying with these regulations, especially if Cal OSHA is going to respond to an accident, and focus in on your portable ladder program, training, and the way that your employees use it. We often see citations related to proper use and proper selection. Those are a focus of the division. And then we also see a lot of citations stemming from the training aspect of the regulation. Oftentimes, training on portable ladders is hands-on training, and employers either forget or it's just not top of mind to document that an employee has been trained on these types of equipment. And so the division will cite training, the training section, and the employer won't be able to show that its employees have been trained on the portable ladders. So definitely check to make sure you are documenting training. Definitely make sure you're training employees on proper use and ensuring that they are using the portable ladders in the proper way, and that also they're using the correct type of ladders. And on that, I think Rachel will cover number 8.
Yep, I'll take number 8, and then just one last word on portable ladders. I've also seen citations lately on placement of ladders, that employees have not properly placed ladders. Also ensure that you are tagging out ladders that are defective, and that should not be used. We see that happen commonly where a ladder may have some type of defect and it's not properly marked for not use, and an employee may grab it. So again, pretty low hanging fruit for the division. Areas where doesn't take a heavy lift necessarily to improve your safety program on, but unfortunately they're easy ones to kind of miss. So number 8, hazard communication. Always on the top in the list. It obviously addresses employees' safe use of hazardous chemicals. It has, in addition, requirements for the manufacturers and importers to classify the hazardous chemicals. Here in California, it's also coupled with Prop 65. So it enlarges that standard out here. All employers must provide information to their employees about hazardous chemicals to which they may be exposed. And the basic requirements are the written HazCom program, labels and warnings, SDSs, employee information and training. So where I see citations come out most often out of this standard is not necessarily related to employee incidents. Where I see this happen most often is the division is inspecting for something else. They ask for a copy of the HazCom program and training, and they like to go through line by line and look for compliance issues. So, again, and this is also an area and a takeaway from today is that your written programs and your written training, double check to make sure that you're hitting all of the elements of the standard, and sometimes have a second set of eyes take a look at it, because things that one person may think is sufficient, everyone has different perspectives. So have somebody else take a look at to think that, for them to review to ensure that they also agree that you're hitting the elements. Because again, it's pretty low hanging fruit. So the two ways that I've seen it for training come up most frequently in citations is there is a requirement, of course, that you have to notify employees of hazardous chemicals that they may be exposed to in their work areas. And Cal OSHA can take issue with the specificity of that and how that information is communicated to employees. So I see a lot of employers say, well, here's the SDSs over here. And that's not, Cal OSHA is not going to find that sufficient. They're going to expect you to go over the list of what those employees may be exposed to. Just saying how to find the SDSs won't cover that. Another area that I see that is overlooked in the training and in the plan is the list of employee rights. So you have to provide, there's a list of employee rights under HAZCOM, and those tend to get overlooked or tend to get summarized. And that's an easy one where Cal OSHA is looking to ensure that employers have that included. So definitely double check and make sure that those are in there. Those are easy areas where they like to hit. And of course, outside of those, the main one we always see is, making sure your SDSs are up to date and your SDSs are maintained as they're supposed to be maintained. Inspectors love to ask for copies of those SDSs or to review those SDSs. If you use an electronic system, make sure that you have other ways of accessing SDSs in the event that your electronic system is not available. And with that, I'll let Sam go over portable fire extinguishers.
So number 7 is, as Rachel said, portable fire extinguishers. Those are found in 6151. It applies to, similar to the ladders, it applies to a broad range of topics, including placement, use, maintenance, and testing. There's also inspection requirements and training requirements that all employers need to follow. The main issue we see here is related to the inspection requirement. The regulation requires that fire extinguishers be visually inspected monthly. But then there's also a requirement for a more intensive annual inspection. And those annual inspections need to be documented and recorded, retained for a year. And what we often see is that employers will do the more intensive annual inspection, but it won't be documented. The division comes in and asks for their annual inspection documents, and they can't produce it, and then they get a very easy citation for failing to inspect the fire extinguisher. So just make sure you're aware of the requirements of this section if you have fire extinguishers in your workplace, and always make sure you're documenting any inspections you do, so if the division asks, you're prepared to provide that to them.
And this is an area, usually fire extinguishers, are on your list of for your periodic inspection. So your checklist that you have, your folks going through. So, if it's not on there, obviously make sure that they are. But it's also one area where you really want to make sure that your folks that are doing your periodic inspections and looking at these fire extinguishers know what they're looking for and specifically what they should be doing. Because again, as Sam mentioned, it's one that gets overlooked frequently, and the documentation and tends to be one where Cal OSHA asks for, and if you can't produce it, it's an easy citation. This is one of those citations, where again, you don't necessarily see it as part of the related inspection. So you're not seeing, Cal OSHA come in as part of a injury, and there was a use of a fire extinguisher that was part of that. Usually we see this as part of ancillary part of the inspection, they just so happen to be walking past the fire extinguishers, or, more common than not, we see a situation where, they come in after a incident or an injury, and they can't find, or they don't find any accident related citations or violations, and they're really starting to kind of look at things like your portable fire extinguishers, things like that, as well. And so it's just low hanging fruit for them. It's really hard to get out of these citations once that they've been issued. And they're also ones that can potentially be easy repeats. So if you have a lot of facilities throughout the state, it's very easy to overlook these keeping these up to date. And if you have it happen in one area or in one facility, you most likely you may have it in other facilities. So it's just another one to make sure that it's being reviewed properly and documented properly, and everyone who is doing those reviews knows how to do that. So lockout, tagout. Again, this one really shouldn't be a surprise. It is one, that is on the list, of course, for a reason, and that is, you see a good amount of injuries that come out of improper lockout, tagout, mostly dealing with, finger amputations, things like that. So, it certainly can lead to significant injuries, and if not properly done. And unfortunately, it is one of those areas where, no matter what policies and procedures you may have in place or the training, it's one that employees tend to, you have a higher level of employees maybe doing some workarounds or working quickly and not always following your policies and procedures and training. And so, in certain industries, we see a significant amount of these. It's also one, again, that's can easily be a repeat. And so you certainly want to stay on top of it, because it can certainly accumulate easily. And it's also one, when talking to Cal OSHA, when talking to district managers, they really have a hard time settling these from their perspective, in their viewpoints. These, have a lot of the misuse or not using lockout, tagout can, have serious consequences. So they tend to be reluctant, in my experience, to settle these and to give, any kind of good faith to employers on this one. So it's certainly one, from the outset, that of course can lead to a good amount of injuries, and Cal OSHA is aware of that, and certainly takes that into account when they're in these inspections and issuing citations. So of course, it's the control of hazardous energy for cleaning, repairing, servicing, adjusting operations of machines and equipment in which an unexpected energization or release of stored energy could cause injury to employees. So you must have hazardous energy control procedures, and those have to, be machine specific unless you're having a grouping. And that is one area that we see a lot of citations, that there may be general lockout, tagout procedures, but not lockout, tagout procedures specific to the machines. So that is certainly a focus. And, you know, periodic inspections, there is a requirement for periodic inspections, including at least annually. And that, again, is one where, you know, Cal OSHA is focusing. So if you have an injury related, and lockout, tagout may not have been properly performed, or it's at issue, you know that they're going to be looking at your procedures, and you know that they're going to be looking at whether or not it was reviewed periodically and at least annually. And, you know, where I see employers tend to have issue here is the documentation of that. So they may have performed that, but it was not properly documented. And so it can't, you know, you can't prove that to Cal OSHA. So make sure that, you know, your folks that are doing that are properly documenting it. And of course, you know, the training component of it, again, that's also where we see a good amount of citations. So one, not only around proper training, and then training when there are changes to procedures, but also the documentation of that training. So, you know, documenting, again, easy stuff for Cal OSHA. And then one of the other things that is different here in California as opposed to the federal level, and I think a lot of California employers miss, especially if you are a national employer and have a lot of folks happening, is that whenever you have outside servicing personnel that are engaged in activities that require lotto, the on-site employer's lotto or tagout procedure shall be followed. So if you have folks that are coming in and performing lotto, they have to follow your procedures. That is the opposite of the federal standard that requires them to follow their own. So I certainly see employers, national employers that have kind of a general lotto policy that have that included, get dinged by Cal OSHA time and time again, because their national policy says that, but in California, we have the opposite rule, and that's one that Cal OSHA just loves to focus on. I also see that come up when, for instance, maybe when you have you don't do, for instance, electrical work, you have an outside contractor come in to perform electrical work, and you're not following that provision, even though, and there's an incident, even though, you know, that is, you know, on the contractor, you can still get a citation for not following that provision. So I want to make sure everyone is aware of that difference, and that is an easy one for folks to pick up on.
All right, so we're entering the top 5, which means these are probably going to start to look very familiar. And starting with number 5, we have reporting serious injuries and illnesses. Obviously, these are found in 342. You all know employers must immediately report any serious injury or illness or death if an employee incurring in a place of employment or in connection with any employment. In 2020, the definition of serious injury changed, so just make sure you're keeping up with those changes. And since the pandemic started, we've seen the division take a really broad interpretation of this regulation, and also have some pretty questionable positions related to reporting. So we are definitely seeing this as an emphasis point from the division, and that they will take some positions to uphold citations that don't exactly make sense. But we also see that this is a violation that can very easily result in a repeat. If you have any issues in your reporting line of command or in your policy, it's very easy for this to rear its head multiple times, and you just really want to make sure that you're tight on this procedure because you don't want to get those repeat violations. Another thing we suggest is make sure that your supervisors understand their obligations relating to reporting injuries and illnesses. We often see safety people tell us after they get a citation that they just found out about the incident, and then we find out that the manager knew a day before or even earlier than the safety people did. And so it's just really important that all employers make sure that supervisors understand the importance and the urgency of making sure that injury and illnesses are reported up the chain of command in a really timely manner. Because you all know the division is extremely strict on that reporting time period. Number 4 is COVID-19. As Rachel said at the beginning of this presentation, these numbers are based on 2022. So we're hoping that COVID-19 will either be much lower in the new updated list or maybe not on it at all. But in 2022, it was the 4th highest cited standard. So COVID-19 for the division is not gone. The prevention standard is still in effect, and it's changed significantly in the last year, 6 months to a year. CDPH continues to issue new guidance about COVID-19, and a lot of provisions within the prevention regulation are tied to CDPH guidance. And so you want to be aware of any guidance that comes out from public health and its impact on your COVID-19 plan and the prevention regulation. Just this year or last year, they had changes to the infectious period and the outbreak definitions, so that significantly changed. And then there were a lot of notice requirements to employees that were contained in the original COVID-19 prevention standard that have sunsetted and are no longer required. So just make sure you keep up on what your actual obligations are, because there are already a lot. And if you don't have to provide notice on a certain topic, it would be best that you leave that off your list. And ultimately just confirm that your plan is compliant. It's very easy for the division to come in and ask for your COVID-19 prevention plan, cross-reference it with the requirements, and if there's anything missing from it, that's an easy citation. As Rachel said earlier, these low-hanging fruits are best to avoid because the division will latch onto them extremely quickly.
Yeah, and just to piggyback on what Sam was saying, you know, I know we're all tired of COVID. Believe it or not, the division, I think, is tired of COVID too. I've had multiple district managers tell me, you know, they just want to see compliant plans. You know, when they come in and they ask for your COVID plan, they just, you know, they're going to go down their checklist. They just want to make sure it's compliant. The last inspection that I worked on, I had a inspector, you know, say, I'm going to ask for your COVID plan. You know, I'm going to give you, 4 days to get these documents together, you know, review your COVID plan, make sure it's compliant. And if it's not compliant, I'm going to give you a citation. So, you know, again, it's low hanging fruit. It's really, you know, take the time and just review to make sure that you've hit all of those elements. You know, you know, there is a template program that Cal OSHA has out that you can double check your own self on. You know, certainly there's additional, you know, always use caution when using a Cal OSHA template plan, because they like to throw things in there that aren't actually required. But it is a nice way sometimes just to double check to make sure that you have everything in there that the law requires. You know, certainly we can help review that for you. But, you know, every time I review a COVID-19 plan, I still, you know, I still find things that are missing from the employer side. So it's to say that, you know, it's easy to do. And it's a easy one for Cal OSHA to pick up on. And it's one where, you know, this is their kind of focus for COVID right now. the plan, and they're really not getting too deep into the other pieces of it, for general industry. I won't say that for healthcare necessarily, but, so just keep that in mind. And as Sam mentioned, there's been a lot of changes. The one thing to also note is that, we saw the big order from CDPH earlier this year. Just note that not all local counties and cities have adopted that. And so if your local public health has not adopted that local public health a stance is going to be what applies. So just ensure that you've taken a review of that, and that all of the places that you may operate are following CDPH, because that may not be the case and they're not required to. All right, so we're in the top 3. There should be no surprises here. I'm sure everyone can guess what they're going to be. But number 3 is the injury and illness prevention program for construction. So construction has a special IIPP section. It has the regular IIPP requirements. It incorporates that, and then it has some additional things for construction. And that's going to include adopting a written code of safe practices that relates to the employer's operations. So I will tell you off the bat, outside of kind of, this being the catch-all where they, get employers for anything that doesn't fall under a specific standard, and we'll talk about that one a little bit more in a minute. But the Code of Safe Practices is where I see the most citations for construction. And I see it related. Cal OSHA likes to hone in on the fact of whether or not those safe practices listed actually relate to the employer's operations. So I've actually had Cal OSHA take issue with certain things listed that don't apply, or that not enough was provided. And that, again, that's an area of emphasis. There is a template out there of a code of safe practices that Cal OSHA has put out or has previously put out. I've had employers adopt that as theirs, and Cal OSHA will cite you if you just adopt that without making modifications for your work operations. So that's easy for them. If they see their template there and it's just verbatim what they've done, that's a signal to them that it hasn't been tailored for your workplace. So, that would be my cautionary tale on this one, and where you're going to see it the most. This one always kind of ranks in the top 5. That's not really a surprise to anyone, but it's one that's out there and easy citations. Number 2, outdoor heat illness prevention. This is an emphasis area. There's no doubt about it. Probably the number 1 emphasis area for Cal OSHA is outdoor heat illness, or heat illness really generally. And we see this, one, obviously by the amount of citations issued. Number 2, that's huge, especially considering that not every employer in the state has outdoor workers. So if you imagine that, this is a standard that only relates to outdoor workers and it's still number 2, that's a good amount of citations that you're seeing, and that's a good amount of emphasis. And it is not going away. It has been number 2 for a very long time. It's going to continue. It's going to continue to be an emphasis area. And again, this is one where when Cal OSHA comes in, if you have outdoor workers, expect they are going to ask for it. They just will. It doesn't matter what the inspection's about. They will ask for this program, and they will go through it line by line. I will tell you, it happens every inspection. They get nitpicky about the plan, and that is an easy place for them to get citations. They also get really nitpicky about that training. So make sure that all of that's documented, it's all up to date, all of your folks are trained, and you're hitting all of the points. The one area we also see, I would say the number one area where I see employers kind of leave out of their plan or not train is the supply enough water to drink at least 1 quart per hour. For whatever reason, I see folks put into their plans a little bit softer language of, make sure you drink enough water or something like that. Cal OSHA wants to see that specific language. So make sure it's in there, make sure that's what happens in practice, make sure that's what's available to employees. And there's also a provision in there about encouraging employers to drink water. And I've seen citations for that employers have not encouraged employees to drink water. So, again, these are the areas where you really want to make sure that you're getting in there and that's their focus. Providing access to shade and encourage employees to take cool down recovery breaks at least every 5 minutes. Weather monitoring, additional requirements that apply for high heat. All of those are in there. We've seen a lot of case law in the last couple of years coming about, where should water be, where the shade should be. So this has been litigated significantly, and you'll see that it is an emphasis area for the appeals board. They like to take these cases. They will actually, there was a case last year in Rios Farming where it was about access to water if it was as close as practicable. The employer lost at the ALJ level, didn't appeal, and the appeals board took it up on its own motion because they wanted to decide the issue. So it is an emphasis area for everybody, without a doubt. And there is a current Cal OSHA special emphasis program for both indoor and outdoor heat. So indoor heat, most likely getting a vote, that regulation most likely getting a vote in March or April of this year. That should put it into effect July 1. So if you have facilities that may be subject to indoor heat, make sure you are on top of that now, because that's coming and that's going to be an emphasis area. And even, if something crazy happens where they don't get that regulation adopted in time this summer, they're still going to get it under the IIPP standard. So you're going to be subject to it one way or the other. And so, it's just going to continue to be a major area. Number 1, injury and illness prevention program. Should be absolutely no surprise to anybody. This is the number 1. It is the catch-all for folks that maybe not as familiar with Cal OSHA. It's sort of like our general duty clause, but it's much broader. And it basically, if you didn't evaluate a hazard effectively, here's where they're going to get you. Or, they're going to try to get you at least. So here is, I'm not going to go through all of the requirements of the IIPP. They're here. There are templates available on the Cal OSHA website. Again, those have a lot of additional things in there that are not required. So be mindful of that. A couple years ago, they did add an access section, a new requirement that has specific requirements for how employees can access it. So if you haven't updated your IIPP in a while, make sure that's in there. People are getting citations all over for that. Make sure everything's properly documented. The IIPP has very specific ways that it wants training to be documented. And I see citations for not including the trainer's name, things like that all of the time. And those are easy repeats for large employers. For your inspections, make sure those are properly documented with corrective actions documented as well. Again, that's where I see it all the time. You have inspections, and then you don't have the corrective actions also documented. They love that citation. A couple notable mentions, that we've either seen in past years, aerosol transmissible disease standard, respiratory protection, that obviously went up during COVID. Silica, silica has had a revival with the new ETS, so we'll probably see some more of those. And let's, quickly, here's the top for Fed OSHA. So we see fall protection, HAZCOM, ladders, Lotto, those same no matter what. However, on here, you certainly see a different, it looks very different compared to what Cal OSHA's list looks like. So the takeaway here is, you can now easily see where the emphasis areas are for Cal OSHA versus on the federal level. And it's quite a stark difference in looking at. So when you're looking at your programs here in California, know that it's going to be a different lens than what you see on the federal level. Predictions for 2023, 2024. For 2023, obviously, IIPP will always be the king of California. That's not going anywhere. Your HIP will dominate. Continue to see a rise of late and failure to reports. That's been a real emphasis for Cal OSHA. COVID will drop off. We'll probably, by 2025, Cal OSHA is supposed to have an infectious disease standard. We haven't seen that yet, so doubtful we'll see it in time for the rollback of COVID, but it's certainly out there. Maybe a return of respiratory protection, potentially as we see lead and silica, things like that, emphasis areas. Additional potentials for 2024. Our new regulations, revised regulations, indoor heat, lead, silica ETS. Workplace violence prevention, that goes into effect July 1. I expect that to be a huge emphasis area for Cal OSHA. They're going to be looking at those plans. They're going to be looking at those trainings. Make sure you have that ready to go. So the best practices for this data, again, review those policies, procedures, and training, low-hanging fruit. Are these things that are easily, employee complaints or easily, picked up by employees, things like that? And are things here a particular risk for injury or illnesses? So, or specifically Lotto, things like that. Here's the rest of our Cal OSHA webinar series for the rest of the year. If you're interested, either, you can sign up at our website or email us and we'll sign you up. Our regular Fed OSHA. Please also subscribe to our Cal OSHA blog. You're not automatically signed up for that. So if you're getting webinar information, that doesn't necessarily mean that you're signed up for the blog, and that's where we update it very frequently about what's going on with Cal OSHA. So make sure you do that. We do have special programs around compliance for workplace violence. So if you need some assistance getting those programs together, please reach out to us, and we're happy to help. So thank you everybody for your time. I hope this was helpful. If we weren't able to answer a question, feel free to reach out to us. Here is our contact information, and we're happy to get some additional questions answered, and hope to see you on the next webinars.